If you work in a high-risk industry, or maybe you're studying the law that governs it, you'll know that just following the rules, well, that's only part of the story. Today, we're doing a real deep dive into a key piece of South African legislation, the Mine Health and Safety Act 29 of 1996. It's been amended over the years, of course, and now it stands as this consolidated framework for, well, for one of the most complex legal areas in the country.
Exactly. And this act, it's not just a list of don'ts. It really represents a fundamental shift in thinking about health and safety in mining. It's about moving away from purely prescriptive rules, where the law tells you exactly how to do everything, towards a more performance-based system, one that demands proactive risk management.
Right. Which is why we wanted to do this deep dive. Whether you're just curious about how accountability works in mining, or perhaps you're a law student grappling with these corporate duties, our goal here is to break down its main aims, the pretty strict duties it puts on both employers and employees, and also look at the powerful body set up to actually enforce a genuine safety culture.
Okay.
Let's get into it. Where do we start? The why, I suppose. So the act kicks off with its core objectives. And like you said, it's not just about stopping accidents, is it? It seems more about building safety into the system itself. I count 9 main objectives here, but maybe the most important one, or at least the most foundational, seems to be promoting a culture of health and safety that feels much bigger than just compliance.
It absolutely is. And what's interesting right from Chapter 1 is how it sets up this idea of collective responsibility. It doesn't just point fingers. It explicitly calls for tripartite participation. So that's the employer, the employees, and the state all working together, identifying hazards. And crucially, it sets out the order for dealing with them. Eliminate first, then control, then minimize. That hierarchy is key.
And it's not operating in a vacuum either. I noticed the objectives specifically mention giving effect to the Republic's public international law obligations on mine safety. So it's linking this whole domestic framework to, well, global standards for protecting workers.
Precisely. It connects those dots internationally. And speaking of worker protection, nothing feels quite as immediate as the rights given directly to the person right there at the workface.
Yes, this is where it gets really interesting for the employees themselves. The act locks in what people often call the stop work right, that fundamental right to refuse to work if things look dangerous.
That power is explicitly written into the law, yes. Section 23. An employee can leave any working place if, with reasonable justification, it seems like there's a serious danger to their health or safety. And importantly, they don't need to wait for a manager's okay or an inspector to arrive. It's an immediate, actionable right. Self-preservation, essentially.
And there are financial protections, too, aren't there, to make sure this right isn't, well, punished?
Absolutely. Section 24 is clear. The employer can't deduct anything from wages or make an employee pay for safety measures they're obliged to provide, whether that's specific training, PPE, medical checks. The cost of safety sits squarely with the employer.
Okay. So Chapter 1 sets the vision, the rights. Chapter 2 then feels like where the act brings out the hammer, maybe, defining who's responsible and what they must do.
Yeah.
So who ultimately carries the can when things go wrong?
Well, the primary legal responsibility lies with the employer. The fundamental duty, under Section 2, is to ensure, and this is key as far as reasonably practicable, that the mine is designed, built, equipped, basically set up for safe operation and a healthy environment. And that duty doesn't just stop. It runs through the whole life of the mine, right up to decommissioning.
But mining operations are huge, complex. Duties inevitably get delegated down, often to a mine manager on site. How does the Act handle that?
It tackles that head-on with the duty placed on the Chief Executive Officer, the CEO. That's Section 2A. The CEO has to take reasonable steps to make sure the employer's health and safety functions are actually being properly performed throughout the organization.
Okay, so the CEO needs to ensure the systems are working.
Yes, but, and this is a critical point, especially for law students studying this, delegating tasks, say to the manager appointed under Section 3, does not get the employer off the hook for their statutory duties. Accountability stays right at the top. You can delegate the doing, but not the ultimate legal responsibility. That really shifted how companies had to approach safety from the boardroom down.
Got it. That top-level accountability then supports the whole system of prevention, doesn't it?
Yeah.
You mentioned the shift from prescriptive to performance rules. Let's talk about risk management.
Right, that's Section 11, really the cornerstone of the preventative side. It mandates identifying, assessing, and recording all significant hazards and risks. Standard stuff, maybe, but the really revolutionary part is the required order for taking action. Management can't just say, jump to handing out dust masks as the first step.
Okay, so what does that mandatory order look like? How does it work practically?
The Act is very specific. Measures have to be implemented in this order. First, try to eliminate the risk altogether. If you can't, then control the risk at its source. If that's not possible, then minimize the risk. And only after trying those, as a last resort, do you provide personal protective equipment, PPE. And then you follow up with monitoring.
So it forces engineering solutions first before relying on gear or behavior.
Exactly. It pushes for inherently safer design. And that monitoring isn't optional either.
Right, continuous checks are built in.
Correct. The Act requires specific ongoing checks. Things like occupational hygiene measurements, actually testing the air for dust, the noise levels, vibration, things like that. And at the same time, employers have to set up a proper system of medical surveillance. This needs to be overseen by an occupational medical practitioner, and it's designed to catch occupational diseases early on.
And what about when things do go wrong, when prevention fails?
Then the post-incident duties kick in, and they're quite demanding. Employers must investigate all accidents, serious illnesses, or anything that threatens health. That investigation needs to start quickly, be wrapped up within 30 days generally, and result in a formal report.
And that report isn't just for filing, I assume.
No, definitely not. It has to dig into the causes, including the underlying or root causes, and crucially recommend concrete steps to prevent it happening again. A copy has to go to the principal inspector of mines and the Mines Health and Safety Committee within that time frame. It forces rapid learning from failures.
Okay, let's shift focus a bit. You mentioned the tripartite structure earlier, employer, employee, state. Chapters 3 and 4 really flesh that out, don't they? Starting right down at the mine level.
That's right. The grassroots level involves health and safety representatives, H&S reps, and health and safety committees. The thresholds are clear. If a mine has 20 or more employees, they need H&S reps. If it hits 100 employees, they need a formal H&S committee.
And these reps, they're not just there to sort of observe, they have actual power.
Oh yes, considerable statutory power. Section 30 outlines their rights. They can represent employees on safety matters, identify hazards themselves, participate in inspections and audits conducted by management or the inspectorate. And critically, an H&S rep has the power to direct any employee to leave a working place if they reasonably believe it poses a serious danger. That mirrors the employee's own right, but gives the rep a broader scope.
Wow. Okay, so that puts real immediate control in the hands of people right there on the ground.
It does. It empowers those closest to the potential hazards. Then, moving up from the mine level, you have the collaboration continuing at the national policy level through these statutory bodies.
You mean things like the Mine Health and Safety Council, the MHSC?
Exactly. The MHSC is the embodiment of that tripartite principle at the highest advisory level. Its structure tells the story. 5 members from employers, 5 from employees, 4 from the state, and it's shared by the Chief Inspector of Mines. Its main job is to advise the minister on health and safety policy and legislation, making sure that regulations are developed with input from all sides.
And alongside that, there's the MQA, the Mining Qualifications Authority.
Correct. The MQA focuses specifically on the skills and training side. It advises on qualifications, frameworks, training standards, setting curricula, basically ensuring the workforce has the right competencies for safe mining. It helps align training with the evolving risks and technologies in the industry.
And if disagreements pop up within these structures, say about elections for reps or access to information.
There's a process for that too. Disputes arising specifically under Chapter 3, related to these participatory structures, get routed through the CCMA, the Commission for Conciliation, Mediation, and Arbitration for Resolution.
Right. Now, let's talk enforcement, the real teeth of the Act, as people often say. That brings us to the Mine Health and Safety Inspectorate in Chapter 5.
Yes, the inspectorate wields really quite formidable authority. Under Section 50, an inspector can enter any mine at any time, day or night, without needing a warrant or even giving advance notice. Their purpose: monitoring compliance, enforcing the Act. That level of unrestricted access really highlights the seriousness of the regulatory regime.
And perhaps their most dramatic power is the ability to actually stop work, to shut down an operation.
That's Section 54. If an inspector believes, reasonably, that any practice, condition, or situation at a mine is dangerous or unhealthy, they can issue an instruction. That instruction could be to stop operations entirely, suspend a part of the operation, or impose specific conditions. And crucially, that instruction takes effect immediately.
Immediately, wow.
Immediately. And it stays in force unless and until it's formally set aside by the Chief Inspector of Mines or through a legal challenge. You can imagine the financial impact of that power. It fundamentally changes the conversation between the regulator and the mine.
Absolutely. But it's not just about shutdowns, is it? There are fines, too.
Yes, the Act provides for administrative fines as well. This is Section 55A and B. It's a non-criminal route for imposing penalties. An inspector can investigate noncompliance and then recommend an administrative fine to the principal inspector of mines, who has the authority to actually impose it up to a prescribed maximum. It allows for quicker financial consequences.
But it can escalate beyond fines, potentially into the legal system. Chapter 7 deals with legal proceedings and actual offenses.
It can. For disputes about how the Act should be interpreted or applied, disagreements over duties, rights, procedures, the Labor Court has exclusive jurisdiction. That's Section 82. But it's important to note, the Labor Court doesn't handle the criminal side of things.
And there is a criminal side.
Well, yes. Section 86 makes it clear that negligent acts or omissions that cause serious injury or illness are criminal offenses, and the penalties under Section 92 can be severe. Potentially a fine up to 3 million rands, or imprisonment for up to 5 years, or even both. And just worth noting, there's also the uncommenced Section 86A sitting there, drafted but not yet activated, which aims to impose corporate criminal liability specifically in cases causing death or serious injury. It signals the direction of travel towards even stricter accountability.
And finally, there's protection against victimization, too.
Crucial point. Section 83 explicitly prohibits any discrimination against an employee for exercising their rights under the Act, like refusing dangerous work or raising safety concerns.
Okay, so wrapping this up, it's clear this act is far more than just a rulebook. It's a comprehensive, evolving framework that really reshapes accountability. It puts the main burden for safety squarely on the employer, demands proactive risk elimination, not just management, and builds this strong participatory system from the individual worker's right to stop work, right up to national policy bodies.
I think for anyone learning about this Act, the real takeaway is that focus on prevention first. Understanding that hierarchy of controls, eliminate, control, minimize, then PPE is fundamental. And recognizing how central that tripartite governance model, the council, the MQA is, to how health and safety evolves in the industry. It's built on collaboration.
So here's a final thought to leave you with. Considering those immense powers given to the inspectorate, especially that Section 54 power to halt multi-million rand operations instantly, what does that really mean for industry leaders? Does that sheer power, the threat of catastrophic disruption, impose a responsibility that goes beyond just ticking compliance boxes? Does it ultimately force a deeper, more ethical commitment to fostering that culture of health and safety the Act envisions, perhaps in a way that simple fines never could? Something to think about.